Ms. Smith failed to appear on May 6th of 2022 for a show cause hearing before referee Bradfield. Currently, her bond is set at $1,344. This is her 9th warrant. Her last payment was June of 2021, and that was a $300 bond. Friend of the court is asking that the next hearing be scheduled March 29th at 8 a.m. before your honor.
Ms. Smith, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing. When's the next hearing, Ms. Brown?
March 29th at 8 a.m.
March 29th, 2023 at, well, is it 8 or 8:45? We don't have any at 9.
It's at 8.
8 o'clock a.m.
Yes.
You will get notice of that in writing. Ma'am, are you able to post a bond?
No.
No? Okay. Well, the court does note that it is your 9th bench warrant, and you have not, again, paid for a considerable period of time, for years, in fact, other than being able to collect the bond money previously. What I'm going to do, I am reducing your bond slightly. I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay, thank you, ma'am.
Mr. Witcher failed to appear on March 4th of 2019 for a show cause hearing before referee Fryer. Currently, his bond is set at $6,095. This is his 4th bench warrant. His last payment was a bond that was posted in November of 2021. Friend of the court is asking that his next hearing be scheduled on March 29th at 8:45 a.m.
Thank you. Mr. Witcher, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenant that the next hearing be held on March 29, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I'm not.
Okay. Well, the court notes that it is your 4th bench warrant in this matter, and again, that you've not paid in a considerable period of time, for a matter of years, in fact. As a result, the court, I will reduce your bond, but I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions, sir?
Nope. Nope.
Okay. Court will conclude this matter, everyone. 40 a.m. You're free. Yes, I'll ask first, Mr. Andrews, as I note in this matter that you were defaulted on October 18, 2022. Are you disputing or contesting anything in this matter?
Just the child support.
Okay, well, what you're going to have to do is you're going to have to file some paperwork to contest that. What the court will do, the court will take the proofs. I will hold up entry of the judgment for a week. I'll give you a week to file whatever it is you have to file, sir, to dispute this matter. If you don't file within the week, the court will enter the judgment at that particular time. You understand that?
Yes, Your Honor.
Okay.
And Alicia, do you recall coming into my office in August of 22 to sign a complaint for divorce?
Yes.
And were the allegations contained in that complaint true and accurate at the time?
Yes, ma'am.
And do they remain true and accurate today?
Yes, ma'am.
You state that there had been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that your marriage can be preserved. Does that remain true today?
Yes, ma'am.
And you also stated you'd lived in Calhoun County at least 10 days and you'd lived in the state of Michigan for at least 180 days. Was that true at the time that you filed the divorce complaint?
Yes, ma'am.
And you've had a chance to review the judgment that judge will enter in this matter?
Yes, ma'am.
And do you believe that the provisions contained in that judgment, as they pertain to custody and parenting time, are in the best interest of your 2 minor children?
Yes, ma'am.
And do you believe that the property allocations are fair and equitable?
Yes, ma'am.
And one last question, are you pregnant at this time?
No, ma'am.
Thank you, if it may please the court.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. Court will preserve the proofs in this matter pending any action taken by Mr. Andrews in the next week. Again, Mr. Andrews, if you don't file any paperwork in this matter, the court will enter the judgment and the UCSO a week from now. So court will end this matter at 8:45 a.m. You're free to go. Have a good day.
Mr. Glazier, is Mr.
Thank you.
Woods, Joshua Woods,
Thank
planning
you.
to appear?
No, this is a pro-con. They're in agreement. We submitted a consent judgment of divorce to be executed.
Ellie Woods versus Joshua Woods. Today is Monday, March 20th, 2023 at 8:46 a.m. Attorney Matt Glazier represents
And
plaintiff.
you came into my office about September 20th of 2022 to have a discussion about a divorce. A complaint was prepared and you signed that complaint. Is that correct?
That's correct.
And then that complaint was filed with the court. You and your husband have had discussions about a divorce. You've decided to go forward with the divorce. So in that complaint, we allege that the objects of matrimony had been destroyed. I'm sorry, the marital relationship had broken down such that there remains no reasonable likelihood that the marital relationship could be preserved. Is that correct?
That's correct.
And can you briefly tell the court what led to the marital relationship breakdown?
Josh and I just grew apart. Our marriage grew apart.
Okay. And so you and he have been discussing things and matters, and you reduced the resolution to a consent judgment for the court to sign. Is that correct?
That is correct.
And the copy that we submitted to the court, you reviewed that, you signed it, I signed it, and there was a signature line that was for Joshua. Have you seen his signature in the past?
Yes.
And was that his signature on the signature line that bears his name?
Yeah.
Okay. Likewise, there's a child support provision and paperwork addressing that as well. Is that correct?
That is correct.
And likewise, his signature appears on that, as does yours.
Correct.
Okay. And you're asking, so the total of the consent judgment as well as the child support documents, that completely resolves all the issues in the marital estate. Is that correct?
That is correct.
Are you asking the court to enter that order?
Yes.
I believe I've covered basics, Your Honor.
Okay. The court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The file is in order. We do have a consent judgment of divorce and UCSO signed by all of the parties and their respective attorneys. As a result, the court will enter that, which I have done now. Ms. Woods, you are divorced. Good luck to you. I hope everything works out for you. And the court will end this matter at 8:49 a.m. You're free to go. Have a good Henderson on behalf of the defendant. This matter is before the court on the defendant's motion to reinstate parenting time. Ms. Henderson.
Good morning, Your Honor. Thank you. On January 23, this court held a hearing on plaintiff's motion to suspend parenting time. At that point, I was not yet retained by Mr. Basor, and unfortunately, he did not appear to the hearing, having received the notice of that hearing just Thursday the week before and not being able to retain counsel. The court did suspend his parenting time. That was the only ruling of the court, and the court stated it would entertain motions to reinstate parenting time. Immediately upon being retained, which was approximately 4:58 p.m. on January 23rd, the day after the day of the hearing, but after the hearing occurred, defendant's counsel emailed plaintiff's counsel asking if a resolution would be possible. I would ask the court to note that plaintiff's counsel provides an untruthful statement in her response stating that I contacted her prior to the hearing, which is completely false. I did not even meet with Mr. Basor until approximately 3:30 p.m. on the day of the hearing, Your Honor. So I would ask the court to note that and see what other things are untruthful in that response provided by plaintiff's counsel. Upon speaking with plaintiff's counsel, it was determined that even though there are no formal rulings made or conditions for reinstatement of parenting time, that my client would undergo an independent psychological evaluation. And immediately upon having agreed on that, my client reached out to Life Coach Psychology, which is located in 2 offices. One of them is about 15 minutes away from my client's residence and his place of employment in Berrien Springs. He resides in Niles. And so my client scheduled his independent psychological evaluation through my participation on the NA case rotation. I know that Dr. Haugen was at that time booking well into spring. And so Life Coach has been used by this court more often recently because Dr. Haugen is so busy. My client attended the independent psychological evaluation on February 14 and March 2nd and completed a comprehensive evaluation, the result of which was provided to to plaintiff's counsel on March 8, 2023. A copy of this evaluation is attached to the motion. I understand that plaintiff's counsel is stating it's hearsay. However, I do have concerns about the court granting the motion based on completely hearsay allegations that were contained in that motion, Your Honor. And had my client appeared, I don't know if the court would have made that ruling. The results of the evaluation verbatim state that there is no evidence that Jordan Basor is an angry and aggressive person, and there is no indication from the evaluation that this would point him to being an unsafe parent. The traits that were revealed in the test have no bearing on the quality of his parenting of his children, Your Honor. There were no specific recommendations made based on nothing essentially harmful in his behavior or traits found as relates to parenting. However, Mr. Basor re-engaged in weekly counseling through Life Coach Psychology that he has been attending at this point every week after work. During that counseling, Your Honor, he is working on healthy relationships. He is working on issues of substance abuse, any other issues that were mentioned in the independent psychological evaluation, such as anxiety, insecurity, and difficulty with socialization. And at this point, defendant has done what was communicated with plaintiff's counsel. He is willing to provide any and all releases necessary for Ms. Thomas to review his progress. He is willing to continue and plans to continue that counseling on a weekly basis. Your Honor, we're asking that his parenting time be reinstated. Any of our requests resulted in very brief video parenting time, mostly with his daughter, Mia. However, I do have to say that after the filing of the motion, plaintiff allowed the son to call my client, Brody, and Brody acted like nothing happened, told his daddy missed him. So clearly the allegations of him being afraid or not wanting to have any contact with my client do not check out at this point, Your Honor. We're asking that my client be granted his parenting time that he has pursuant to the judgment of divorce. He has spring break this year with the children. He would like to exercise this parenting time. He is willing to have his mother supervise it if that makes plaintiff more comfortable. He is going to continue mental health treatment, Your Honor, at this point. He is willing to do whatever the court needs him to do to get his children back. However, I think he has shown through his participation in the evaluation and counseling already that he is acting upon his desire to see his children again. Thank you, Your Honor.
Ms. Thomas, what's your response, and address, if you would, if there's any, your client's agreeable if in fact that paternal grandmother does supervise?
Okay, thank you, Your Honor. Your Honor, first of all, I would apologize that I noticed that our response had the former counsel as opposed to Ms. Henderson on it. I do take exception to Ms. Henderson's comments this morning regarding what time of the day we spoke on that Monday. In that I leave at 4 p.m. on Monday, every Monday, so that's not correct. So I'm not sure what that's about, but whatever. Although counsel alleges that the order of this court was based upon false allegations, defendant did nothing to let this court know and or otherwise acknowledge that he was even aware of what was going on. He obviously, now we know he did have notice, he had proper notice. He failed and refused to attend the January 23rd, 2023 hearing, even though he knew it was about having his parenting time suspended. He still did not attend. And that's interesting because it's not as though he didn't know how to ask for an adjournment, because in fact, he had asked for an adjournment in the enforcement portion of this case. So he did know how to ask, he just didn't. Since immediately prior to the entry of the judgment of divorce, the defendant has repeatedly alleged plaintiff is lying to the court, but is yet to offer any evidence of same. And in fact, failed to file an answer to this or otherwise respond to this present motion. There still is not a response to this motion in the court file, allowing this court to believe that the allegations that were made by plaintiff are in fact truthful. And that did support a suspension of parenting time. The suspension of parenting time was not about plaintiff attempting to interfere in defendant's relationship with the minor children. Rather, it was based upon the party's son, his unusual response to the parenting time that happened at defendant's home over New Year's weekend, when he cried and begged to not have to go back to his dad's home and begged to talk to your honor personally, explaining to you why he shouldn't have to do that. After he had previously always looked forward to going to dad's house. He'd always wanted to go. He'd always looked forward to going. He knew that there's limited rules and he wanted that. That combined with the defendant's history of mental health issues, his violation of the plaintiff's personal protection order against him, and then plaintiff becoming aware that there was domestic violence at plaintiff's home, and apparently that weekend, not in front of the children, but apparently it wasn't the first time of domestic violence in defendant's home. And therefore, in that time, our plaintiff's understanding is that the plaintiff's then girlfriend ended up with broken ribs. So clearly there's a lot more than what counsel would have this court believe. After conferring actually with the defendant's mother, that's when, in fact, plaintiff decided that, the parenting weekend was missed. And based upon the totality of all of that, she decided that this was the absolute only way to go at this point. Although there was an agreement that a psychological evaluation should occur, defendant at the apparent discretion of or direction of his counsel selected his own evaluator, wherein as we had requested Dr. Haugen. I note that Lady Henderson did indicate this morning that Dr. Haugen is gone apparently until spring, but that's not true. I have talked to Dr. Haugen numerous times over the past 3 weeks, so definitely that's not the case. He's in fact is I could have gotten him in that same week. I just didn't know until after that was the day of the appointment that I found out. So obviously it was too late. The purpose of the evaluation was to determine the presence of anger and or aggressive issues, and was to be inclusive of an alcohol and drug assessment, which has not yet been completed. The defendant has a history of mental health issues, which led to the inclusion of language in the judgment of divorce that defendant shall follow all recommendations, referrals from his current healthcare provider regarding mental health treatment. He has failed to comply with that directive. More importantly, the party's minor son is experiencing some significant trauma at the thought of having to go to in-person contact with the defendant. He's working with the resilience coach at his school, which is a Mr. Tramonday, and he's helping him kind of with his emotions, but also helping him with skills to kind of help when Brody's frustrated. Both children are scheduled for counseling evaluations to determine their needs. Even though there is no order for plaintiff to do so, she has in fact been allowing telephone and video chat contact with the defendant. The older minor child is still extremely upset and refused to have any contact for several sessions. He then has agreed to do one. He was okay. Again, that was with the help and guidance of the resilience coach from his school. Defendant was given the younger minor child's soccer schedule, inviting him to games, and he failed to go to any of her games, similar to the way he fails to exercise his Wednesday evening parenting time. Once the children have been evaluated, there can be a better directive as to the children's best interests and what is best for them. Meanwhile, defendant has failed to comply with the judgment of divorce and did not undergo drug and alcohol assessment as counsel had agreed. Finally, plaintiff objects to the inclusion of defendant's exhibit, obviously, as it includes double hearsay and cites not only an incorrect reason for the evaluation and lays the evaluation for the purposes of a custody. In other words, that the evaluation was done because there's a custody battle, which isn't true, and unknown whether true or not. Plaintiff was unaware that an evaluation kept the defendant out of jail for the personal protection order. That's what it says in the evaluation itself, that the evaluator gives credence to defendant's actions, and she gives credence to his actions based upon him having lost custody of his children and wanting his children back. But what the court needs to realize, it wasn't that he lost his children's parenting time and then had these actions. These actions are the reason that he lost parenting time with his children. And again, we just want the children to be safe and what's in their best interest. Based upon the inaccuracies, the results cannot really be for the purpose of the test and the reason for the test and what it's about. I don't think that the results can even be given credibility. We do know that this morning counsel has indicated that he has no anger issues and that we should go back to the way it was. But as recently as Saturday of this weekend, the defendant sent a text, mistakenly apparently, but still said a text that says, quote, "I'm going to tell this lawyer off. She's telling me I have court at 9 Monday." Then also a text saying, apologizing to his daughter and saying that he is just trying so hard to get you back and I just can't win. I worked 5 days straight and I'm just mentally exhausted. I'm so sorry, honey. I just want you back. But mom doesn't want that. Again, a violation of the minor child's inalienable rights, an attempt to get the child to be angry with mom because that she can't see dad and interfering in that relationship. So clearly there are still ongoing issues. We're asking at this point that, and I'm cognizant of the fact that counsel has indicated that grandma is willing to step up. We would be okay with supervised parenting time with grandma. We have a really hard time with the idea that after dad has gone for a long time now, without having the kids with him, that it would be for an extended 9-day period. So if we could somehow work that out and either trade spring breaks or something along those lines, that would be better. We're also asking that this court require defendant to comply with the mental health treatment as set forth in the judgment of divorce and comport with the parties' agreement regarding drug and alcohol assessment, with the defendant required to undergo any recommended treatment as a result thereof. It appears from the police reports that alcohol may have been involved in the what transpired between defendant and his girlfriend over the New Year's weekend. We're asking that the children be evaluated with recommendations for any treatment as it may relate to any kind of trauma from being in dad's care and improving their relationship with the defendant. The defendant be required to participate in any recommended therapy with the minor children as may be requested by their therapist. We're asking that the court require defendant to undergo the healthy relation. The plaintiff was told as part of the PPO case that defendant is to undergo a healthy relationships course, and that was supposed to occur in resulting from the personal protection order. There's no, in the violation thereof, actually, there is no indicator that that's happened, although that was part of the agreement and that was made with the plaintiff in that case. So at this point, based upon the fear and all the other things with regard to his regular parenting time being supervised, the plaintiff is okay with that as long as it's supervised by grandma, meaning his mother, defendant's mother. But with the domestic violence and other things, we just, with no supervision, parenting time is not in their best interest until we find out what's going on with them. What is the reason for this happening? Because it was a 180 turnaround for the minor child, the older minor child. And let's look not at the defendant getting or not getting his parenting time. Let's look at these children and find out what's going on, why the big change, what's going on that's an exact opposite of what had been happening prior to that, and look at their best interests and their needs. So at this point, I would ask that the court not allow extended parenting time unless, if grandma's able to supervise it the entire time, that's fine, but we would need to verify that first. Otherwise, if it's just the alternate week parenting time, having grandma supervise is fine with the plaintiff. The defendant has not been exercising Wednesdays anyway, and I believe he has to let her know if he plans to in advance anyway. So I don't know that that's such a problem because, again, grandma could contact her and let her know. But at this point, to go back to the unsupervised schedule.
Thomas, please wrap this up. I don't have all morning for this, okay?
Yep, that's fine. So to go back to the unsupervised parenting time without finding out first what's going on with the children and their best interest is not good. It's not a right decision in this case.
Okay, thank you. Well, in this matter, as Ms. Henderson stated, that she didn't know if the court would have granted the motion had the defendant appeared. but the fact is the defendant did not appear. And obviously he was aware of it. He could have appeared, could have requested an adjournment or any number of other things he could have done. He didn't do, and there's consequences for not appearing in court. The court will not grant the motion to reinstate at this time, except insofar as the court will grant the defendant parenting time that is supervised by the paternal grandmother. And the provisions are such that the grandmother has to be present at all times during the parenting time. So if she's not able to do so, then he wouldn't get that particular parenting time. Court will do that. The court will order that the children would continue in counseling and the parties would participate as recommended by the counselor. Court would order that the defendant would participate in a healthy relationship course, and further that he would comply with all the provisions related to the judgment of divorce. And court will allow you, Ms. Henderson, to prepare that order, submit it under a 7-day notice of entry. And after we've had some of that counseling completed, have recommendations, then you can contact the court and we will set the matter for an evidentiary hearing.
Thank you, Your Honor. Is the parenting time schedule provided Grandma can supervise as provided in the judgment of divorce at this time?
I have not changed that other than making it supervised.
Thank you, Your Honor. She will be able to supervise all of it. Thank you.
Court will end this matter at 9:19 a.m. You're free to go. Have a good day. Defendant,
Thank you.
this matter is before the court on the defendant's motion to hold plaintiff in contempt. Mr. Sullivan.
Your Honor, a couple of things. First of all, the motion is laid out with particularity and proof embedded in it. The motion speaks to several orders of the court that have been in place, many of which have been in place since the judgment was entered on August 6, 2015, and additional orders which have been in place for some time are also referenced in the motion. The evidence presented, these are not just allegations, but evidence within the motion, clearly indicate that the plaintiff has repeatedly violated the inalienable rights of children provision, the joint legal custody provision, and the supplemental orders that were entered in this case to the detriment of the minor children. The Michigan Child Custody Act is designed to promote a good and strong relationship between children and both parents. The inalienable rights provision, supplemented by joint legal custody provisions, clearly order that each parent is to promote the affection of the children with the other parent, not directly or indirectly influence the children to prejudice the child from the other parent, to promote the affectionate relationship between the children and the other parent. You know, Judge, these are legislative laws and court orders that must be followed and repeatedly weren't to the detriment of the minor children. And for that reason, we are asking for the relief that we seek in the relief portion of this motion. There are several points that we request. First, we are requesting immediate compliance with the orders of the court that have been in place for reasons that are in the best interest of the minor children. We're asking for the court to order immediate compliance and to indicate to the plaintiff what sanctions will be applied if that doesn't occur. We're also asking the court to hold her in contempt for violation of court orders. We're asking for make-up parenting time, attorney fees, sanctions. We're asking that she undergo a psychological evaluation and provide the results of that to court and counsel. And what other relief the court deems appropriate, award that to the defendant.
Okay, thank you. Okay, Ms. Swellover, what's your response?
First off, I've hired Lisa McNiff and she is unable to join today, so we are asking for an adjournment.
Okay. Well, I wish you would have done that before Mr. Sullivan went through everything, but that's fine. What we're going to do is in this particular matter is obviously Ms. Swellover does want counsel. What the court's going to do is the court is going to refer the matter to the referee for an evidentiary hearing on this particular matter. That'll give Ms. McNiff time to get into the case and to be able to respond. Further, the court will, however, note that the orders that are in place will remain in place and are enforceable. And if a party violates those orders, they risk sanctions as far as court costs, jail time if appropriate in these particular cases. So all I'll say to the plaintiff is make sure that you comply with the orders. If you don't, you do risk those particular sanctions. So. But we'll do-
May I make,
Yeah, go ahead.
just one additional point. Judge, the defendant's parenting time resumes on Wednesday after school, and we expect compliance with that.
I've said that the orders that are in place will remain in place. If they're not complied with, then that is a basis for contempt action. And so that's all I'll say to Ms. Swellover. She'll have to speak to her attorney. But the court expects that those orders in place will be complied with. So
Thank you, Your Honor.
we will refer the matter to the referee and you'll get a hearing date at that time. Thank you.
Thank you.
Court will end this matter at 9:24 a.m. You're free to go. Have a good day.
At 9:27 a.m.
Court will note the appearance of Ms. Reed on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for occupational therapy. Ms. Reed, you can proceed.
Thank you, Judge. We did submit this motion recently to the court because the minor child Bailey, who is 9 years old, she's the youngest, recently completed a multidisciplinary report for the Calhoun Intermediate School District. And throughout the course of that evaluation, Bailey displayed some emotional responses, not only some educational deficiencies, but some emotional responses that had the counselor making a recommendation to mom, who was the parent who participated in the evaluation, that she should be in counseling. And along with that, Bailey's teacher, Miss Herman, has also begun to notice some behavior in Bailey that has required her to reach out to mom to say, hey, can you help with this? Bailey is being disruptive in class. She's acting out. She's running out of the room. She's yelling. She's whistling. She's acting disrespectfully. And so again, during that evaluation that was done by the district, Cody Wetlaufer, who is a school psychologist, recommended to mom that Bailey not only be in occupational therapy, but that she should be in counseling to work through some of these issues. And so we are asking your honor to grant our motion. Mom carries the child's insurance, is more than willing to facilitate setting her up with a counselor, and we would ask the court to order that.
Okay, thank you. Mr. Smith, what's your response to the motion?
My response would be if being recommended through the school district as a perfectly fine thing to do. I'm not attached to it. I agree with she did have a moment in the classroom one day, and I don't feel as though she has those moments every day. It wasn't brought to my attention until this motion was filed. So I contacted the school to try to make sure that family one is also contacted when they feel as though there's an issue in the classroom. Yeah, I just think that, I mean, it's definitely something we can work on, and we'd like to try to make sure that she's taken care of.
Okay. Well, it seems to be, again, a thoughtful, reasoned response. The court will order that Bailey would participate in occupational therapy and any other counseling as recommended by the counselor, because I don't know what the counselor possibly will recommend. But again, I guess you'd say, to eliminate having to come back, the court will order that counseling too, should other counseling be recommended. Ms. Reed, you can prepare that order, submit it under 7-day notice. I guess I'll ask at this point, I know we're supposed to be in later this week for a continuation of trial. Is this something that we should have completed before we continue with trial, Ms. Reed? What's your thoughts?
Judge, I don't think so. We've obviously been in front of your honor on this matter for over a year. The majority of our witnesses have presented, and at our last hearing, your honor had mentioned that our witness list was pretty well set. And so I think that my client would prefer to finish the trial, proceed with, moving Bailey, and Braxton's also enrolled in counseling, continue to move those processes forward, but complete the trial this week.
Okay. Mr. Brown, what are your thoughts on that?
Mr. Smith?
I'm sorry, yes, go ahead, I was looking at something else.
No problem, sir. We completely understand. I would have to honestly say that maybe we should wait until this is done, because we still haven't received anything, any type of paperwork on the evaluation of Braxton, which was done in December. We haven't received any of that, so we don't know exactly the guidelines of what was done or questions that were asked, answers, and all those good things. So I think maybe we should hold off and see, you know, what's exactly needed for Bailey. That way, going forward as a family, we can both sides of us can be fully prepared for what we need and what's being expected of us through the counseling, because it's not just for her, it's also for us. That's what the SMILE program taught us. So I think that would be my recommendation, Your Honor.
Okay.
Judge,
Go ahead, Ms. Reed.
I guess what I would say is that, you know, we would still maintain that we prefer to complete the trial this week. We believe that part of the reason that these children are having some of these reactions is due to the contentious nature of this case, and we'd like to get that put behind us so the family can begin to move forward. If Your Honor is inclined to adjourn the trial, I would ask that we be allowed then to modify our witness lists and our exhibit lists to include these counselors and their testimony, recommendations, and any reports that are completed in order to really get an accurate picture of what these children are experiencing.
Mr. Smith, do you have any problem with, at least at this point, if we do adjourn, that we would simply add the counselors in as potential witnesses in this matter?
I do believe that their report should be sufficient enough for the counselors, as opposed to adding them as witnesses. The report should be sufficient enough to tell us what's going on and what's recommended, Your Honor.
Well, and I understand that, but there may be, sometimes you read those reports and there's a deficiency or clarification that you need. I don't want to foreclose Ms. Reed from using that. Based upon what's been stated, the court does believe it's appropriate, and the court does state that based on what's been raised, that it would be helpful to the court to have some understanding as to what those issues are affecting the children. And so the court at this point is going to adjourn the trial scheduled for later this week. But I will allow, again, the counselors to submit those reports to the parties and to the court. And should either party desire to have the counselors testify, that the court would allow those persons to be joined as witnesses in this matter. Ms. Reed, is it your motion? I'll ask that you would prepare the order, which would reflect that. And then we'll proceed as soon as we get something from the counselor, a recommendation. When we do get those recommendations or report, Ms. Reed, contact the court, and we will set this matter so that we can get it completed.
Okay, Judge, I will do that. Thank you.
Okay, thank you. Thank you both. The court will conclude this matter at 9:35 Umlauf on behalf of the plaintiff. Mr. Umlauf has submitted an order for revocation of paternity and to add party in this matter. I guess I'll ask Ms. Diaz, do you have any opposition to that order?
Yes, sir. I've tried since the last court to get Jason to go and do the DNA. And he told the children last night, in the state of Michigan, I don't have no child. So I don't think he's planning on helping us out, sir, at all.
Well, what we're going to do is, I understand that the court will sign the order. There is sufficient basis in the motion and at that hearing to order that he comply with and submit to DNA testing. So the court will order that. And if he's not going to participate or not willing, the court will address that at that time. But at this particular point, the court will proceed. Mr. Umlauf, has your client submitted? I don't recall the case. Has he submitted to DNA testing?
I don't believe he has, Your Honor.
Why don't we do this, Mr. Umlauf? The court will simply, I'm going to change that, and I'd ask that you modify the order to state that the plaintiff and Mr. Jackson would submit, and at least, obviously, for purposes of excluding your client, I'll have that information available to us. So if you would just change the order to make that addition, including the plaintiff as well will be able to then exclude him if he is in fact determined not to have a probability of paternity. Court will note the
I will do that.
appearance of
Thank you, Your
Ms.
Honor.
Podolsky on behalf
Thank
of
you.
the plaintiff and Ms.
Court one.
Pazno on behalf of the defendant. This matter is before the court on the plaintiff's motion to modify parenting time, defendant's motion to modify parenting time, and for a right of first refusal. Ms. Podolsky.
Thank you, Your Honor. Our motion was pretty straightforward. These parties did not have a holiday schedule in their current order. The minor child was much younger when this schedule was created. He was not yet school age. So we do believe at this point, now that he is school age, it is appropriate to implement the Calhoun County standard holiday schedule, to also include summer vacation periods. These parties do exercise joint physical and legal custody. However, they do so on like a typical 2-2-3 basis. So we believe in the summer moving to a week on, week off schedule to allow each of them to have some uninterrupted time with the minor child, to take vacations and do things during that time off of school would be appropriate. And we requested that exchange for that time be 3:30. Implementing both the summer vacation schedule and the Calhoun County standard holiday schedule, neither of those would change the custodial environment. These parties would continue to exercise 50-50 parenting time. In terms of defendants' motions and their requests, they have stated that these parties don't follow their current schedule, but that is not true. They have followed this schedule almost to a T. Have they accommodated each other in the past when they need to? Absolutely, because they've been able to co-parent. But beyond that, they have been following their current schedule. My client lives with his parents. They are a huge part of the minor child's life. They help as needed with childcare, sometimes picking up and dropping off to school if my client has to work. We do not believe that their request for a right of first refusal is appropriate. We don't agree with it. Each party can seek any childcare that he or she needs at those times that it is needed. And my client is using his parents, who again, he lives with. Some allegations were made regarding medical care for the child. We deny those allegations that were made. The child is well cared for in the home of my client by both my client, again, and his parents. They have not had any issues with the health or wellness of the child. He is given everything he needs, from medication to love and attention. My client simply does not go to urgent care or a doctor every time that there are the sniffles or the sneezes. The most egregious allegation, though, that was made in their motion has to do with this iPad that the defendant accessed without permission. My client was at the defendant's home at her request. He was fixing a bathtub for her. When he left to go get parts to make the repair, she illegally accessed the iPad. She did so without permission and then proceeded to take screenshots of messages that she didn't find appropriate. These were not messages that were seen by the minor children. None of this was content seen by the minor child. This was all done by the defendant without permission from the plaintiff. So she has created this scenario to try and convince this court that the minor child is at danger of being exposed to negative content, but that is not the case. The minor child has been allowed to use the iPad in the past under the supervision of my client. He does so to play games. He is not reading messages. He cannot read messages at this point in time, and he's not seeing any inappropriate content at all. This was the defendant on her own creating this situation and accessing that iPad without permission. We do not believe that anything that they have stated in their motion rises to the level outlined in Vardarka to change custody or parenting time. And it does appear they agree with our request to implement the Calhoun County standard holiday schedule. So at this point today, we are asking that their motion in its entirety be dismissed. We're asking that the Calhoun County standard holiday schedule be implemented to include week on, week off in the summer vacation periods.
Okay, thank you. Ms. Pazno, is that correct that you are agreeable to standard holiday and summer parenting time?
Your Honor, that's partly correct. We are in agreement to the standard holiday parenting time. We are not in agreement to the week on, week off parenting time. And my client believes that due to the fact of Jackson's young age, that week on, week off is not in the minor child's best interest regarding their motion. Do you want me to go further in regards to my response to their motion and then my motion?
Yep, go ahead.
Thanks. In response to their motion at first, as I indicated, my client is in agreement to the holiday schedule, just not the week on, week off. due to the minor child's age. I do believe that there is a change in circumstance and clearly a dispute in fact in regards to this minor child regarding dad's exercising of parenting time. They indicate that the minor child has a strong relationship with the grandparents, and that's probably true due to the fact that 90% of dad's parenting time is with the grandparents and not with the father in this matter. There's been some exchanges with the parties where they have been able to co-parent. However, it seems to be that anytime the father in this matter doesn't like something that the mom does in this case, issues are created. What we're asking for is due to the fact that Mike, or the dad in this matter, is not spending time with a minor child, which is one of the parenting time factors of him exercising his parenting time, that this court take a look at the parenting time structure of these parties, as well as the opportunity for my client to have the right of first refusal. It's always better for a minor child to be with a parent rather than a grandparent or any third party in this situation. Also, as part of my motion is a motion to modify child support due to the fact that there's been a change in circumstance regarding child support. Back when the order entered previously, the parties' incomes were calculated at $12,000 and $15,000 a year. The father in this matter owns his own business. It's a construction company. He makes substantially more than $15,000 a year. And in addition, there's been a change in my client's income as well. We would ask that a hearing be held in that regard. I do have subpoenas out for dad to respond to that are due March 24th, and I'm awaiting that information. In regards to the iPad issue, it's major concern in regards to my client. The minor child does have access to this iPad. She did not illegally get into this iPad. The minor child was playing on the iPad, sitting next to her. The father left the house, or my client's house, at that point in time to go get something. All these text messages started popping up. The child was on the iPad at the time as she was sitting right next to her. So she clicked on them and saw inappropriate pictures, inappropriate conversations, pictures of people who were not dressed, which raises great concerns in regards to what this minor child has access to, especially due to some of the father's construction has to do with, I'll say, adult venues. So he is also, my client has concerns in regards to what information is being passed through the iPad that he's allowed to play on. We do believe that there's been a change in circumstance to look at the right of first refusal, as well as the structure of dad's parenting time, due to the fact that he's failed to exercise it. And we would ask this court to refer it to the front of the court for a child support evaluation and or hearing, and a hearing on parenting time.
Okay, anything else, Ms. Podolsky?
Thank you, Your Honor. As soon as my client realized that there was an iCloud share between his iPad and phone, he turned that off so that those messages are no longer coming to the iPad. So if the minor child were to be on it, he cannot see them. And the minor child was not on the iPad. The iPad was left on the kitchen counter. It was the defendant who, in fact, accessed the iPad. And as she stated here, she clicked on those messages. And we also deny that 90% of dad's parenting time is spent with the grandparents. The minor child does go to school. The plaintiff father does work full time. And yes, he does reside with his parents, but 90% of his parenting time is not with his parents. He spends the bulk majority of his parenting time with the minor child when they are not at work at school. They have a very loving relationship. They are bonded. They spend a significant amount of time together doing activities, playing. He helps with schoolwork. So we vehemently deny the allegations that they've made. If the court is inclined to do a recalculation of child support, we understand that. We do understand that the defendant alleges she is self-employed. However, we do believe she's an able-bodied individual who could go out and get a job today working $17 an hour. So if it's necessary, it would be prudent to impute her at a wage at which she could go earn today. Lastly, Your Honor, as it relates to the summer parenting time, it is very standard in almost every case that has a standard summer schedule that the parties exercise week on, week off. This child is not any different than the children in those cases. We have two parents who both want to spend quality time with him in the summer, be able to go away for a few days or take a trip somewhere. And on their current summer schedule, they are unable to do so. So we do believe that it is important to implement the week on, week off summer schedule for those purposes. And we do not believe a right of first refusal is appropriate in this matter.
Thank you. Well, the parties in this case apparently agree and have agreed on the record that, again, we should alternate the standard holiday parenting time. So the court will grant that as the parties are in agreement. The court does note that the parties otherwise have disagreed as it relates to the summer parenting time and the issue of the support. As a result, the court will refer the issue of parenting time, summer parenting time, and child support to the referee for a hearing. The referee can consider imputation if it's appropriate in this particular matter. Court notes that the parties have, again, based upon the allegations, have had difficulty in some ways facilitating parenting time, and the court's not going to add to that problem by ordering a right of first refusal. The court doesn't believe that that's appropriate. The court will deny that request. The court further, it was in the pleadings that the parties had, at least one of the parties had requested that the child be allowed, or that the, I think it was the plaintiff would be allowed to facilitate transportation of the child with an adult, another adult. So the court will allow an adult known to the child to provide transportation to and from parenting time. And that applies with both parties. So both parties have the right to have a third party adult transport the child if that child is, or that person is known to the child. And as that will cover everything at this point, I'll ask Ms. Podolsky, you would prepare that order, submit it under a 7-day notice of entry, and then we will do the referral order to the referee. That will conclude this matter, and at 10:15 a.m. you're free to go. Have a good day.
Thank you, Your Honor.
Magnuson, on behalf of the front of the court, this matter has been brought pursuant to the defendant's motion to set aside referee recommendation. Mr. Wallace, just so you know, the court doesn't set aside those recommendations unless you can establish there was a factual or legal error to do so. I don't set them aside just because you're not happy with the result. So what do you believe to be the factual or legal error the referee made?
Well, I put it aside because I definitely don't make, I just started a new job. I make like half of what I make now. I don't make as much as I did before. I only work, the last job I had was area-wide transport. I was working almost 80 hours a week. Now I'm working only 40 hours a week. I was making with area-wide, I was making over $4,000 a month. Now I'm making maybe $2,500 a month. I getting denied. I don't know what you guys can do about it, but I know my wife, well, soon to be ex-wife, hopefully, she like denies me my son. I haven't seen my son in over a month. And I mean, I know that's another matter that has to get further in with courts, but.
Okay, you're right, sir. What happens as it relates to court will inform you that support and parenting time are not mutually dependent.
Right.
And what happens if she is not providing with parenting time and you're entitled to that, you can file a motion to enforce your parenting time, and the court would do that. The court is, I religiously guard those rights to parenting time. So you can do that, but that's not the subject of today because that's not involved in the referee's determination. Mr. Magnuson, what's your position in this matter on behalf of the front of the court?
Well, I would ask the order to stand, Your Honor. It would appear, and I'm not trying to speak for the defendant, but that what he's seeking to do is modify this order based on a change in circumstances. Just to complete the record, we did file this case back in October. We pled and we eventually attributed zero income for mom, which based on his answer, defendant agreed with. We did have a hearing in front of the referee. Both parties were present. And the referee established support amounts based on the incomes that were testified to. And Mr. Wallace was attributed with 104 overnights, although there was no specific parenting time established at that time. And so with the resulting order, we have a support amount of $644 a month plus 34 in ordinary medical for a total of $678, which is approximately a little over $100 a month more than he was paying out of pocket informally. So I believe that the hearing was conducted appropriately. The calculations are appropriate based on the information that was provided and available at the time. So I would ask that the order stay in place.
Okay, thank you. Mr. Wallace, in this matter, as been asked by Mr. Magnuson, is obviously a lot of things can change. If your income has changed since that hearing, you have a right to seek modification, just like you have a right to seek enforcement of your parenting time.
Right.
But that's not a basis to object to the referee. And I understand lay individuals maybe not understand, say, well, he set support. Yeah, he set support, but based upon a finding at that time. And if your income has changed since that time, you have a right to seek modification again. So what you're going to have to do is you're going to have to file a motion to, again, enforce your parenting time and to modify your support obligation based upon the new facts and circumstances. Okay?
So where do I go to do that?
Go to the county, the circuit court clerk's office and
Okay.
ask.
In front of the court has the pro promotion.
Okay, or you can go to the front of the court's office and get the pro promotion packet. It means in pro per, you're appearing on your own. It's a motion to modify. Just
Okay.
ask them, they'll provide you the whole packet. You can fill that out, be very specific as to what you're asking for and why you're entitled to it. And then
Right.
file it and we'll have a subsequent hearing on that, okay? Okay, but otherwise the court will, at this point, deny your motion to set aside the referee order as there's been no factual or legal basis established to set that aside. So with that, the court will conclude this matter at 10:45 a.m. You're free to go. Have a good day. Mr. Schaefer,
Yep.
court will
Thank you.
again note your appearance and that this matter is before the court on the defendant's motion to continue the restrictions. In this matter, it is now 10:45 a.m. The matter was set for 10:30 a.m. The plaintiff has not appeared in this matter, nor has she filed any pleadings in this particular matter. So again, the court will grant your requested relief, Mr. Schaefer, by default, as the plaintiff has not appeared to contest that. I hope I didn't irritate Mr. Schaefer and make him leave. Oh, Mr. Schaefer, you're not able to hear us? That's what appears to be the issue.
Please connecting the audio.
Okay.
There we go.
Mr. Schaefer, I think we need to get you a seeing eye dog or something.
I did, and she just came in and took care of me.
Yes, good. We're glad. I was stating, when you couldn't hear us, that it is now 10:47 a.m. The matter was set for 10:30. This matter is before the court on your client's motion to continue the restrictions. As the plaintiff has not appeared, nor has she filed any pleadings in this matter, the court would grant your requested relief by default. As a result, Mr. Schaefer, you can submit an order continuing those restrictions and submit under the 7-day rule.
Very good, Your Honor. Thank you.
Thank you. You have a good day. The court will end this matter at
$3,346. This is the 11th bench warrant. In the second case, bond is currently $8,976, and this is the 10th bench warrant. He reports no employment, but states that he receives SSI. Last payment made on these accounts was in October of 2020. Front of the court recommends that reasonable bonds be set in each of these matters and they be scheduled for hearing on March 29th, 2023 at 8:45 a.m. before this court.
Mr. Carlton, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on March 29, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir, I don't get my SSI check till on the 1st. I'd rather just make a payment with that.
Okay. Well, I'm going to reduce your bond substantially in hopes that you could get out. I'm going to set your bond in both cases in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you, sir.
Mr. Campbell
Court will,
failed to appear today for an
conclude
adjourned
in
show
this
cause
matter.
hearing. He also is non-compliant. So friend of the court is asking that we issue bench warrants for his arrest and set the bonds per statute.
Court would enter a bench warrant for Mr. Campbell as a result of his failure to appear. The court would set his bond in the amount of 25% of the outstanding arrears or $500, whichever is greater.
The respondent, Brianna Spears, was ordered to appear this morning for a bench warrant hearing. Friend of the court did speak with her. She did waive her right to appear before your honor. Friend of the court is requesting that Ms. Spears be ordered to make a $200 lump sum payment by March 24th, 2023, that the bond of $300 that she posted on March 15th be forfeited, that she be ordered to pay as ordered beginning April 2023, and this matter be adjourned until May 17th, 2023 at 8:00 a.m.
Court would order that Ms. Spears would make a lump sum payment of $200 no later than March 24, 2023. Court would forfeit the bond previously posted by Ms. Spears and will adjourn the matter to May 17, 2023 at 8:00 a.m. to monitor her
Bench warrant hearing scheduled
compliance
for today's
in order
date.
that she comply with.
He
all
made a
orders.
payment to resolve the bench warrant, so there's no bond to address, but friend of the court is asking because he is not paying support as ordered and did not call in for his hearing today that a new bench warrant issue.
Court would enter a bench warrant for Mr. Hill as a result of his failure to appear on today's date. Court would set his bond in the amount of 25% of the outstanding arrears or $500, whichever is greater.
Thank you, Your Honor, and that's all I have.
Okay, thank you. You have a
Brandon
good day.
Ulrich. Mr. Ulrich has failed to appear before your honor today and has failed to comply. Friend of the court requests the bench warrant be issued at the statute amount.
Court would enter a bench warrant for Mr. Ulrich as a result of his failure to appear on today's date. Court would set his bond in the amount of 25% of the outstanding arrears or $500, whichever is greater.
Thank you, Your Honor. In the matter of the following docket, Nathaniel Porter. Friend of the court has met with Mr. Porter. He waived his right to appear for his hearing today. An agreement was reached with him. Mr. Porter is receiving SSI and the EO will be submitting his dockets for closure. Friend of the court is requesting this matter be dismissed at this time.
Dismissals are granted.
Thank you, Your Honor. And lastly, in the matter of docket number 2021-3391 in regards to Trevor Morey. Friend of the court has met with Mr. Morey. He waived his right to appear for his hearing today. An agreement was met for him. Mr. Morey is currently incarcerated. Therefore, friend of the court was requesting that the matter be dismissed to allow the respondent to resolve his pending criminal matters. He is ordered to contact friend of the court within 14 days of his release. Upon his release, he agreed to be ordered into the ELITE program, and he is to continue to pay as ordered upon release.
Okay. The court will, in this matter, dismiss the cases and cancel any bond previously ordered. Would order Mr. Morey to report to the front of the court within 14 days of his release from incarceration, and that upon his release from incarceration, that he would participate in the ELITE program.
Thank you, Your Honor. That's all I have.
Okay, thank you. Have a good day.
000-470 DP involving Antonio Reed, and docket number 2005-00-1091 DM involving Stephen Brown. Mr. Reed and Mr. Brown failed to appear for court this morning. Friend of the court's requesting a bench warrant to issue for their arrest and bond be set per statute.
Court would enter a bench warrant for Mr. Reed and Mr. Brown as a result of their failure to appear on today's hearings. Court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater.
Docket number 2018-003201 DP involving Christopher Banks. Mr. Banks failed to appear for his show cause on March 16th, 2022 before referee Croteau. However, income withholding has started and payments have started to come in. Friend of the court's requesting that Mr. Banks pay as ordered April 1st, 2023, and this hearing be dismissed.
Court would order that Mr. Banks would comply with all orders of the court and will dismiss the case.
The following people failed to appear for show cause hearings before a referee involving Ryan Johnson, S, involving Rashawn Turner, involving Donald Dice, S, involving Terrell Thomas, involving Marcus Lipford, involving Michael By. Friend of the court's requesting a bench warrant to issue for each respondent and that the bonds be set per statute.
Court would enter bench warrants for Mr. Johnson, Mr. Turner, Mr. Guys, Mr. Thomas, Mr. Lipford, and Mr. By as a result of their failure to appear at their respective referee hearings. The court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater, and further would assess court costs of $150 on each of the cases.
Okay, thank you so much.
Okay, thank you.
Yep, bye-bye.
You have a good day.
You too.